will now call 1-2-3-7-8-3 State v. Smith.
May it please the court, James Latta of the Appellate Defender's Office representing Marnez Smith. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor. To begin with a brief recap of the facts in this case, Mr. Smith was convicted of computer crime, theft, multiple acts in this case. And the facts are really that Mr. Smith was a teller at a bank, and the state alleged that he stole $3,200 out of a teller without the customer's knowledge. And that's what led to the convictions. Getting into my issues, I plan to talk today about issue 1 and issue 3 and submit issue 2 on the briefs unless, as I know from yesterday, this court, who knows where we'll go. So that's my plan at the beginning. So starting with issue 1, the the alternative means analysis. The statute itself, I think, admittedly is ambiguous and could be read multiple ways. So I'm going to start with the PIC committee's reading of the statute, because I know I usually get the PIC committee thrown at me. And this time I want the PIC committee's interpretation of the statute for this court to follow that interpretation. And so the PIC instruction, which was the instruction given in this case, reads as follows. The defendant used a computer for the purpose of executing a scheme with the intent to defraud, or for the purpose of obtaining money, or with any other thing of value by means of false or fraudulent pretense or representation. So my primary argument is that the first half of the PIC instruction, as is interpreting the statute, has the element of intent to defraud. There is the defendant must have the intent, that mental state. And specifically, the intent to defraud requires another person. It requires their intent, at least, to have another person act upon their fraud, to get them to give them something. And then the second half of that, after the or, for the purpose of obtaining money or any other thing of value, there is no intentional component to that. And so I would actually argue that second half has no mental culpability. And I would base that argument on this court's recent precedents of Dinkle, which relied on Pulliam, if I'm saying that correctly, where we go down and we look at the alternative means, and we see that some alternative means have mental culpabilities and some don't. And based on my argument that this is an alternative means issue, the second half here, based on this court's reasoning in those cases, there is no mental state. And so that's really the elements that give us the alternative means. Is before the or we have intent to defraud, after the or we just have conduct.
Well, doesn't intent modify both defraud and obtain?
So my first answer is that's not how the PIC committee wrote it, and that's not the PIC committee's interpretation. My second argument was, even if we go that route, which I think that's how the Court of Appeals read it, while my argument I'll allow isn't as strong, because when we now have an intentional component, it's the intent to. It's still different. The intent to defraud requires the person to have the mental culpability to get another person to act and to try to get them to do something. The intent to obtain money by false or fraudulent representation does not require the intent to have another person act to get them to do something. It can, but why would the legislature then have these two? Why would they write it separately? And why would the legislature not just why would they just take out the part with intent to defraud and not just include the false and fraudulent representation if they just wanted it to be all encompassing? So I think based on that, we don't read extra language into statutes. Even if we go your route of interpretation, it's still two different mental states. One's the intent to get someone to act and to try to get them to give you some kind of interest. And the other one is just your intent to just take something, to just act like it doesn't require the victim to actually.
What do you think the phrase false or fraudulent pretense or representation?
Really any kind of dishonest conduct. So I think I know where you're going. I think you're going to say that could include the intent to defraud.
It just seems like the legislature is saying the same thing two different ways,
I-
potentially.
I agree. I agree that false or fraudulent representation could include the intent to defraud, which the Court of Appeals really hung their hat on. But I don't understand why the legislature would put in this extra language. And based on our rules of interpretation, we should interpret this so we don't have this extra language. So that what the legislature really meant was the intent to defraud as we know from its definition, requires the intent to get another person to act to give you some kind of interest. And the second half doesn't require the intent to have someone give it to you. It just requires the intent to go get it. So I think I used the example in
Well,
my
no,
brief.
it says by means of false or fraudulent pretense or representation. And if I just walk down there and grab your keys, I may be committing a theft, but it doesn't require false or fraudulent pretense or representation, does it?
No, not under that, it wouldn't.
So what is that in the statute? By means of false or fraudulent pretense or representation?
Well, I would use the example I used in my brief, where if someone hacks into a bank and they're acting as though they sign in and act as though they're the victim, that would be false or fraudulent representation. But it doesn't require some intent to defraud, it doesn't require the victim actually do something, or it doesn't require the defendant to attempt to induce the victim to do something.
And you're saying that's the added element that's included in the word defraud,
Right,
which is different from false or fraudulent pretense.
right, because we have to read them differently, or else we'd be just having this extra language, which would go against our rules of interpretation. And then so either interpretation, which I will again emphasize, the Pitt committee did not follow that route. There's still no evidence in this case of the intent to defraud. All the evidence that was alleged just showed that Mr. Smith was basically just taking money out of a cash drawer without inducing anyone to give him money. I mean, an example of intent to fraud would be if he lied to was printing out things and trying to get them to sign electronically to show that it was a valid transfer. And there's no evidence of that in this case. In fact, the slips had no signatures whatsoever. And so based on that, and based on this court's precedence of super sufficiency, we would ask that alternative means is missing, and we would ask for a retrial on just the alternative means that sub evidence supported for that first issue. No other questions on that issue. I'll briefly just talk about issue 3. So issue 3 is my restitution issue. And in this case, we had a trial, and the state admits in their brief that the trial proved that Mr. Smith, the evidence tended to show that Mr. Smith stole $3,200. Then at the sentencing, they asked if there was any objection. For unknown reasons, there was $4,100 was requested. And Mr. Smith's counsel was asked what she wanted to do, and she said she had no objection. And she specifically said on the record she had no objection because that's what the trial proved. But we know that the trial did not prove that. And we also know, I mean, I think we can base on that language that the defense counsel just made a mistake. She meant to only allow that $3,200 was proven, or obviously she wouldn't have talked about what was proven at trial. And so based on the unique facts here, the defense didn't put on any evidence at trial. We have undisputed evidence that Mr. Smith supposedly stole this $3,200. I would ask that under this court's precedence, we really don't have a factual basis for that. And I hope that just the lack of objection, we can still go back and get a rehearing.
Is that what you're seeking? Are you seeking a rehearing on this?
It-
In Daly, we laid out a path where once there's an error, or if there's even a miscalculation, the state doesn't get a kind of a second bite at the apple. What should we do here?
That's my first request in my petition, is that you just send this back with an order to just enter the $3,200 since it's undisputed. There's no debate about that. And that would be under Daly is what I would rely on for that. And then my second ask is if this court isn't willing to do that because of the unique circumstances of this case, we would ask at least then for a rehearing. And I would just point out that the state is just trying to procedurally default me in this case on this issue. And I'm not really sure why. I don't know. I thought maybe we could do something unconventional. Maybe this court could ask the state if there's a reason why they requested the $4,100. And if there isn't, why they wouldn't concede that it should just be 3,200.
Mr. Lotta, can I take you back to issue one very quickly? In looking at the statute, subsection A, we're talking about subsection A 2.
Yes.
And you're saying there's alternative means within subsection A2. But subsection A actually has 5 subsections within it. 1, 2, 3, 4, 5. Why wouldn't the legislature have split 2 into 2 different subsections if that's what they had intended?
My honest response would be, I don't know, but I will say they have done it before. This court in State v. Britt looked at the sodomy definition. And if you go read the sodomy definition, it's just a straight definition. And this court read alternative means into the different ways to commit sodomy based on the statutes. So it's done it before. And as this court recognizes with its precedent, it can happen. That's why we talk about having internal additional alternative means. And I would say that would probably be one of the weaker arguments for the state, because because what we really look at is, do we have distinct elements? We look at the conduct, the mental culpability. That's what we're really looking at. And my argument, based on any interpretation of this, is the mental culpability, the intent. It's either not there for half of the statute, or if we're reading it to read with intent to obtain money, it's still a completely different intent that does not require a person. I mean, one, we're requiring a person to have the intent, the mental intent to try to get someone to act under deception. And the other one is just the intent to do something without the person. So one, we need this extra person. I see that as a big difference that we really should get past which I admit is a point for the state. I think we should pass that and get past and really see these alternative means through the intent component.
Would you agree that in this trial, there was 0 evidence of a third person being induced to act?
Yes.
So if that's true, should we apply a harmlessness analysis to this alternative means? Assuming we agree with you that this statute does present alternative means, should we analyze this through a harmlessness lens?
No, I would ask this court to follow its precedent and analyze it under sufficiency of the evidence.
And that you're correct. That's what the court has done in the past, but you're probably also familiar that at least some members of the court have suggested that a harmlessness analysis would be appropriate where one of the means has 0 evidence. So I'm asking you to respond to that.
Right. I understand what you're saying, Your Honor. My response would be that basically I would adopt the reasoning of this court that we just can't know for sure. We're just, this is sufficiency of the evidence. We see juries convict when there's insufficient evidence all the time. And so we really don't know that didn't happen in this case.
I'm sorry to interrupt, but was the jury instructed on the statutory definition of intent to defraud?
Yes, it was. It was provided.
So you think we can't know whether or not some jurors thought that the defendant was guilty of intent to defraud, even though there was 0 evidence of a third person? Absolutely.
I see that, and I have cases all the time where I win sufficiency. Well, not a lot, maybe every once in a while where I win sufficiency of the evidence. So yeah, I absolutely think it's certainly possible. And the jury trial right was just argued in the previous case is so valuable. I don't think we should risk it that some didn't.
I have another question on that point. Now, there is some case law to indicate that the alternative means to be used narrowed by argument. So the argument, I think, in issue number 2 is that both parties argued that this was that the means that applied here was the second to obtain money, property, services.
I would say that number one, would say that doesn't go to our sufficiency analysis, because basically what I was saying with Justice Stiegel was that's what we have in every case where there's insufficiency of evidence. The prosecutor's arguing you should find these elements even though there's an evidence missing. So I don't think you could essentially elect an alternative means, or even if they did, it doesn't go to this court's precedence. And when we look for reversibility, it's just whether there was evidence or not. We don't look to what the prosecutors say or what the defense counsel says in argument. There is no unlike multiple acts instructions, you can't narrow it down. You can't elect which alternative means to follow. We just look at the sufficiency. That's this court's test, and I would submit that that intent to defraud is completely missing any evidence in this case. There's no other questions from this court. Done.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. It is our position that KSA 215839A2 sets forth options within a means and not additional alternative means of committing the crime. This court's standard review is whether a case involves alternative means as a matter of statutory construction subject to unlimited review. We would agree with the Court of Appeals determination that this subsection of the statute does not contain alternative means of committing the crime. The legislature typically signals its intent to create an alternative means by separating alternatives into distinct subsections of the same statute. Here, the legislature did that by creating alternative means for committing unlawful acts concerning computers in subsection A1 through A5. To the state, it makes no sense that the legislature would have done that and then within subsection A2 created additional alternative means instead of just setting that out as a sixth option. So our position is this language that's complained about is descriptive of the types of factual circumstances to prove the conduct that's criminalized under A2, which is the use of a computer system, computer network, or any other property for the purpose of devising or executing a scheme or artifice. Merely describing a material element or a factual circumstance that could prove the crime does not create alternative means.
Well, but the defendant is arguing that there are different elements here. That intent to defraud includes an element that's not included in obtaining money by means of false pretense.
I understand that, and
Disagree with that?
we disagree with that.
What do you do then with 21-5111, which is the statutory definition of intent to defraud, which, as I read it, at least, it says it requires an intent to, quote, induce such other person in reliance on such deception to, transfer property, basically. I'm summarizing the rest of that.
So our position is that is similar to as the Court of Appeals found that deception needed to defraud someone necessarily requires a false or fraudulent pretense or representation by the person committing the fraud, which flows to the other part after the or in the statute, and intent to act under false or fraudulent pretense. Essentially, the intent to defraud or the intent to act under a false or fraudulent pretense is a distinction without a difference.
Are you saying both of those descriptions require a third person to act?
I don't think so. What I'm saying is they both involve dishonest conduct, and that is the specified object here that has been criminalized, because it's the use of a computer, and the specified object of the scheme or artifice is engaging in dishonest conduct.
But again, just the statutory definition of intent to defraud is broader than just dishonest conduct. I mean, it's very specific.
I would agree it's very specific, but I think it goes back to the fact that we know that the legislature, when they are setting out, typically if they want alternative means, they are going to set them out in separate subsections. And here it simply defies, it just doesn't make sense that they would pack additional alternative means into one subsection.
Do you know how or why the jury was instructed on the statutory definition of intent?
I cannot speak
Don't.
and I don't recall. I mean, if there's discussion about that, obviously the record would bear that out. But I don't recall if that was a specific discussion. I do know that that the jury instruction that was given here was also included in the defendant's packet. So it was requested by defendant as well. Additionally, to further our argument, the options within an alternative here, it's our position, do not constitute further alternative means themselves because they do not require proof of an additional and a distinct material element. And as the Court of Appeals found, and we agree, this subsection does not contain further alternative means. So it is our position that the Court of Appeals was correct in their determination on the first issue. Unless there are other questions.
Assume with me that we disagree and that we do find that there are alternative means. You agree there's no evidence of both, of one or the other?
And yes, in the briefing, I did admit that as far as a intent to defraud, if we're parsing that out, the evidence here did not show all of these transactions occurred when the account holder was not present. There was no presence by them. There was no signature by them. But as set out in the brief, assuming everything that the defendant claims to be true, we argue that there was abundant evidence of obtaining money by means of false or fraudulent pretense. And we would ask that this court could reliably determine that the alleged error here was harmless. So we would, understanding what you have found in the past, we would ask for a harmless review in this case under the proposed modified harmlessness approach, and find that there is sufficient evidence of the alleged other alternative means, the intent to act under false or fraudulent pretense. That answer your question?
It does. I guess what I'm struggling with is, as I said here, is what about the bank? I mean, your argument went to the person whose money it was, definitely, but does the bank not have a role here I mean, the bank is holding that money, has some fiduciary responsibility to its account holder. And it seems to me that there's an argument that the bank was, there was an intent to deceive the bank, to induce it to release the money to someone who had no right. Like, what am I missing?
Well, I would admit that in handling this case, for however long I've had this case, I've never actually thought about the bank because we had these 4 account holders. And possibly because of the definition, the statutory definition of intent to defraud is an intent to deceive another person. But as you've stated, yes, the bank is out the money and was basically through his actions induced to turn it over. And if you look at the sentencing journal entry, the restitution goes to the bank. So I wouldn't disagree with you. I've just never thought of, honestly, have never thought about the bank.
Do you know if we have any case law that in the arena of intent to defraud that interprets induce such other person to include digital transactions in which it's the robot,
Right.
it's the computer that's doing, but the computer's been programmed by a person, so there's no actual person acting, but as Justice Lukert's suggesting, presumably there was a defendant had an intent to deceive the computer in order to convince the computer to give him money. Is that an accurate layman's description of what happened?
I would say yes. I mean, he went into the computer, into the accounts. And actually,
And he lied to the computer and the computer gave him money. I mean,
Yeah.
again, is that a really, it's probably way oversimplified explanation?
no, I mean, I think that's what occurs here. Specifically, I don't remember. I know there's the part where the account holders did not sign for this. But yes, he had to go into the computer to do something to get the cash drawer to open.
So that's just my question. Do we know whether we have any case law that says that the language describing an intent to defraud that refers to such other person is broad enough to capture computer programs or digital transactions effectively?
I do not know, because I did not look at that way, but that is, that's an interesting way to think about it. And I mean, that's what happened here.
Even a person that's wearing two hats, I mean, at that point in time, the defendant's wearing the hat of agent of the bank and is in essence defrauding the agent who is doing the teller that's doing the mechanical.
Mhm.
That may be a even slimmer distinction since it's one person, but from a legal standpoint, it is two people in essence, both the fiduciary and the
True, because while he took the money from these 4 accounts, I believe because the restitution is going to the bank, the bank then covered that loss, gave it back to the account holders, so then the bank is out. So I can see, again, I didn't think about it that way, but the way you've described it, I could see that as fitting. I would have to look into it more. If there are no other questions on issue 1, I'll briefly issue 2. So it was our position, and the Court of Appeals agreed that any error in the restitution amount here was invited because the defendant acquiesced to the request for restitution in the amount of $4,100, preventing the state from presenting evidence to support that requested amount.
acquiesce. In context, at least of our jury instruction case law, where we have said that acquiescence isn't enough to invite an error. Why would it be different here?
Here, I thought of that, and I think it is different here because in the realm of jury instructions, you look at whether defense counsel actively pursued or actively did something to make that the court relied on to act, to either give an instruction or not give an instruction, basically inducing the court to do something. Here, the defense counsel's acquiescence essentially induced or caused the state not to put on any evidence to support that number that was different than what was shown.
Does the state have that evidence?
Admittedly, I do know what in my getting into the case, I do know where that number comes from. It is not in the record. If the court wants me to explain, I can, but basically that fact it kind of shows what the court, why we don't have that information. The state didn't present it because the defendant did not object to the amount. And so relying on that, that was the state's request and they didn't prove it up.
But you're saying as an officer of the court, it wasn't a mistake. That there's a real claim there for the difference between.
I didn't read it as a mistake, and I think it's because I know and discovered some of the things going on prior to getting to trial and the charging of the case. So that's why I don't read it as a mistake. Is it possible that was a mistake? Maybe, but defense counsel here was counsel through the entirety of the case, I believe. And so I don't think it was a mistake.
I mean, that's the problem. And one thing, if you say he acquiesced, so we didn't come forward with evidence that we have that would have shown the number. And I understand that. What I don't understand is putting a back door on it and saying, well, there might have been a mistake out there somewhere. Because if it's a mistake, then it's harder for me to believe that the state is harmed by acquiescence. So I think you have to stand right there and tell this court that was a real number and that you didn't get to put on evidence because he acquiesced to it.
I understand that. And if the Chief Justice wants me to explain, again, it's not in the record.
I don't
But
need you to explain anything. I need you to tell me that that's the
It's-
case.
it's
that
a real
you as an
number.
officer of the court believe that that's the case based on what you've seen.
Yes.
That's all I'm getting at.
it's a real number. So we believe because defense counsel did not object and told the court it did not object to that number, that there was an acquiescence. Now, if this court does not agree with the Court of Appeals determination or my argument, we would ask, as opposing counsel said, there are two options. Either you vacate the order and put in the $3,200, which was proved at trial, or send it back and allow us to put the evidence on the record since we didn't have the opportunity at sentencing the first time. And I fully understand that this court has cases where they've said, if we don't prove it up the first time, we don't get another shot. But I believe those are situations where we've had an evidentiary hearing and we just missed the mark in proving the amount. Here, we did not have that opportunity. And if there are no other questions, I would simply ask this court to affirm the decision of the Court of Appeals. Thank you.
May it please the court. I would like to respond to Chief Justice's question about the bank's interest. And in the intent to defraud definition about whether the bank had an interest and Mr. Smith intended to defraud the bank as well. And so there's some evidence of that. In the intent to defraud definition, it uses the word person. And then in that same statute, there's the definition of person. And a person means an individual, public or private corporation, government, partisanship, or unincorporated association. So while maybe the bank's a corporation, which I don't think they put on any evidence of, the computer system certainly isn't any of those things. And certainly property owned by any of those would not.
Well, if you
amount
just
to a person.
substitute the word bank for person in the statute, why doesn't it fit?
Because he didn't have any intent to defraud the bank. He wasn't trying to get the bank to do something.
Well, it says an intention to deceive, I'll just say the bank, and to induce the bank in reliance on the deception to transfer property. Isn't that exactly what happened?
But the bank didn't, I don't understand how you intend to defraud the bank. He just took the money from the
Well,
bank
that-
by
okay,
false or
so
fraudulent pretenses.
What does that mean that he just took the money?
That to me would be under the second half where it's by false or fraudulent.
No, I just
pretenses.
mean factually educate me. What was the actual evidence? Like how precisely did this crime occur? Was it like was it cash? Was there an open
Yeah, he was
drawer? and
basically
he
doing
just
a
walked-
withdrawal without the presence of the,
Okay, so he had to type something into a computer.
yes.
So why isn't that a lie to the bank that induces the bank to then give him money?
My response is that you cannot induce an inanimate object to do something.
What if, but
Without the person that.
well, the definition of a person includes the corporate entity.
I understand. And so this is how I would distinguish that, is the corporate entity as the bank. And then we divvy that down to their personal property and going in and typing into a computer owned by someone. When, without their, I mean, he could do this without the bank. He could do this with any computer. He could have come in from somewhere else. He could have come in from outside and hacked in I mean, you don't need the bank. And I just don't think you can intend to defraud a non-living thing. There's no way to get the bank can't be induced to, there's no intention. And he certainly didn't have the intention to get the bank to believe these things and to then give him the money.
Oh, he
Wasn't
did
that-
all that to cover up the crime so that the bank wouldn't catch him. So that's, I mean, that seems to be a fairly easy supposition to make here. Why else do it? Otherwise, why attribute the withdrawal to a customer? Why not just take money from the drawer? Because he had to have the bank think that the customer took that money out, and the customer is a fiduciary of the bank.
I understand. I would stand by my position that you can't intend to defraud them. And then I'd also argue that the state never raised that argument in its briefs. That would be my position on that.
What about the acquiescence? I mean, essentially, the state's saying that the defendant did a bait and switch here, that you didn't object to the number that went into the journal entry, but now you're saying, oh, wait a minute, this is an error and we didn't invite it. So it seems to me that based on this, the easier way to go is just to send that issue back down to the trial court and let everybody figure out what the right amount is.
And I would also be okay with that. And I would just point out that there's evidence in the record that it wasn't a bait and switch because the trial attorney in this case said that's what it was proved at trial. And that wasn't what was proved at trial, 4,100. And so it wasn't, I would argue it wasn't a bait and switch. Unless there's any other questions, I will rest on my briefs. Thank you, Your Honors.
Thank you to both counsel for your arguments. We will take this case under advisement